Good morning, everybody. I feel compelled to start off with trying to get you all moving a little bit. So let's sing a little bit from the song "Anything Goes." Good authors now who once knew better words now only use four-letter words, writing prose. Okay, so it's good. I'm going to focus on books and competition, and I'm going to talk specifically about two hot cases. Authors Guild versus Google. Is it the case of the century? It certainly raises a lot of questions, among other things, about the nature of competition in the book world. And I want to talk about Sky River versus Oclc. Whose catalog is it anyway? But first, a bit of history. Excerpt from the Alexandria Times Herald. Ptolemy II announces a plan for a universal library. The Open Scrolls Alliance decries a monopoly. Dateline, Alexandria, 286 BCE. Pharaoh Ptolemy II today announced the founding of a universal library to make every scroll in the world available. Critics outside Egypt immediately condemned the proposal as a ploy to build up Alexandria's tourist industry by forcing scholars to come to the city. But what a lovely place it was. And here's another excerpt from history. Tewksbury Times, Manuscript Mania. Gutenberg inks deal with Cloister Consortium. Dateline, Tewksbury, 1438. Bible Baron Johannes Gutenberg today announced an agreement with a consortium of major cloisters to print their entire collection of illuminated manuscripts using his radical new invention, movable type. Prices for gold leaf and parchment plunged in late trading as speculators dumped their stocks. Oh, there's that evil machine. So, is there anything new under Yieldy Helios? Let's just flash forward to 2004. 2004, the Google Print Project was initiated. Yay, boo, yay. 2005, the lawsuit is filed by the Authors Guild, publishers, and others. 3 years later, a settlement is announced. But a settlement in a class action like this has got to get court approval. So there's a period of time for review of that. And in the meantime, the Department of Justice Antitrust Division decides to file a Statement of Interest, or SOI. And then a couple of months later, what do you see? You see a rewritten agreement settling the case in November of '09, which then has to go through a court approval process. And the Department of Justice files yet another Statement of Interest, and a fairness hearing was held just about 9 months ago. And so what are the issues in dispute? Very quickly, you probably know all these. The principal battle is all about copyright laws, ownership, fair use. But the 2008 settlement led to a firestorm of protests and concern about an excessive use, or that is to say, a use of the class action mechanism went far beyond anything that the federal rules allowed. At that point, the Department of Justice weighs in with its Statement of Interest and raises not just issues about the class action mechanism, but also about antitrust, the impact of this settlement on competition. And they started an investigation, and the investigation is technically continuing. I've included here, and I'm assuming at some point in time you all will get copies of this, the citations to where you can find the Department of Justice's two statements. But in a nutshell, this is what they had to say. On the one hand, they were very positive about the concept of the project, breathing life. This is really poetry from the department. Breathing life into millions of works that are now effectively dormant. You see all those dormant things just sitting around. But this project allows users to search the texts of millions of books at no cost, creating a rights registry, enhancing the accessibility of such works for the disabled and others, all worthy objectives. Yeah, come on. Yeah, yeah. All right, but The rights granted to Google under the ASA, that's the amended settlement agreement, confers significant and possibly anti-competitive advantages on a single entity. Google would be the only competitor in the digital marketplace with the rights to exploit a vast array of works in multiple formats. This just rings with enthusiasm. Google would also have the exclusive ability to exploit unclaimed works without risk of liability. The amended settlement agreement's pricing mechanisms also raise antitrust concerns. What's the antitrust problem? Publishers and other search engines may not be able to compete in the future against Google because of Google's enormous lead time on all this, its market share, and the very copyright barriers to entry that led to the lawsuit in the beginning. And what you see is, and this just sends shivers up and down the spines of antitrust lawyers who know that private parties aren't supposed to restructure an industry on their own. The government's supposed to do that. And so there's no legislative authorization for this. So the bottom line of the Department of Justice is that they have reluctantly concluded that the use of the class action mechanism is a bridge too far. Boy, wouldn't that be kind of a good name for a book? I don't know what it would be about, but the other point that they make is that the settlements collectively agreed upon constraints on the rights holders of relationships with Google raise concerns. There's this de facto exclusive access to orphan and rights uncertain works. So, in the public interest, the court should encourage the continuation of settlement discussions between the parties. What do others say? Well, there's these library associations who've weighed in on this, the ALA and others. They take the position that the cost of creating a repository and Google's significant lead time suggests that no other entity will create a competing digital repository for the foreseeable future. And in the absence of competition, the settlement could compromise fundamental library values. The absence of competition, for example, for institutional subscription services, makes libraries particularly vulnerable to profit maximizing prices, a business kind of thing. And there's a fellow named Eric Fraser, a guy who recently had court for Doug Ginsburg, Judge Doug Ginsburg in the D.C. Circuit Court of Appeals. You may remember Judge Ginsburg, who was up for the U.S. Supreme Court until it turned out that he'd taken a sniff of marijuana once in his life. He could have run for president, but not be on the Supreme Court. And he says the same thing that the government has been saying, that the settlement gives Google a lead here, and there are simultaneous agreements with virtually all the right holders, and this simultaneity concentrates pricing power, leading to cartel pricing and monopolization. Others find no antitrust harm. There's a fellow named Mark Lemley, who's an attorney who represents Google in the litigation, and he has written an article in which he says he doesn't find anybody's arguments against the settlement persuasive. And there's Einar Elhaug, a law professor from Harvard, who has received research support, he acknowledges, from Google, and has written a book about why the Google settlement is pro-competitive. So, what's the current status? Still no word after 8 months, make that 9 months. All are eagerly awaiting how Judge Chin will rule on the fairness issue. He can accept it, he can reject it, or he might try to rewrite the settlement and say that he will approve it if everybody buys into these changes. But in the meantime, to all this, he's been promoted to the U.S. Court of Appeals for the Second Circuit in New York. He's now, in effect, got a different job, but he still appears to be holding on to holding on to this case. So at some point we're going to hear some decision, and who knows what it's going to be. What do I think? What do I think? Well, I think that one way or the other, we're going to be dancing to that well-known 1940s swing melody. It's the Boogie Woogie Google Boy Company G. Yeah, everybody now, come on. It's the Boogie Woogie Google Boy Company G. You're going to be humming this the rest of the day. All right, let's going to turn now to Sky River versus Oclc. Complaint in that lawsuit between those two well-known companies was filed July 29th of this year. The dramatis personae are as plaintiffs Sky River and another company called Innovative Interfaces, and the defendant is Oclc, which is defined as Online Computer Library Center. Now, who's Sky River? I suspect everybody in the room knows more about Sky River than I do, but it's a company founded just about a year or so ago to provide a competitive alternative to Oclc, and it promises savings of up to 40%. Savings of up to 40%. Now how much would you pay for a Ginsu carving knife, huh? It boasts contracts with a number of consortia and organizations as time goes on, including last week some libraries from the Oberlin Group. Who's Innovative Interfaces? A company born in the spare bedroom of CEO Jerry Klein's El Cerrito home. You know, I don't make this stuff up. I mean, that's what the website says. And it provides integrated library systems through its products Millennium, Encore, and InReach. See, that's from the first three letters of their, the InReach. Isn't that good? And they boast 1,200 Millennium systems installed. Who's Oclc? Well, it's founded in 1967 by a group of Ohio libraries. It merged with RLG 4 years ago and is now a worldwide organization in which almost 27,000 libraries, archives, and museums in 171 countries are members. Yeah, all right, it's starting to have some success. Membership is open to libraries and other memory organizations of all types and sizes. I have to say, I've never seen that expression before, memory organizations. Are you all part of a memory organization? I can't remember who I'm part of. But now the interesting thing about this lawsuit is that it's actually two lawsuits, two lawsuits in one. One by Sky River and the other by Innovative. Sky River alleges that OLC has monopolized three distinct service markets: the market for bibliographic data, the cataloging of the service of cataloging bibliographic records, and the third is the market for interlibrary lending among academic libraries. Innovative, there's a slightly different spin on it. They claim that Oclc is attempting to monopolize the market for integrated library systems. Okay? Now, I don't know whether that's a market or not, but that's what they say the market is. And they're alleged, Oclc is alleged to be using its monopoly power over its WorldCat database, its cataloging service, and its interlibrary lending service in an attempt to monopolize the market for integrated library systems. Now, more specifically, under the law, what does Sky River claim, and what are the facts that they rely on? The complaint alleges Oclc used its tax-exempt status to gobble up competitors or would-be competitors. And they assert that since 1982, Oclc has used its tax-free profits to acquire 14 for-profit companies. It's alleged that when libraries tried switching to Sky River, Oclc retaliated by imposing price increases of more than 1,100% to upload holdings to the WorldCat database. What's Innovative's claim? Innovative alleges that Oclc used its membership requirements, that is, once you become a member of Oclc, there's requirements imposed upon you, to obtain the agreement, assistance, and services of libraries in developing Oclc products such as WorldCat Local, which they're obliged to purchase, while competitors such as Innovative are excluded from what would be these kind of competitive procurement opportunities. Sort of exclusive dealing and tying arrangements all rolled into one. And what's the status of this case? Well, it was filed in July, the end of July, in San Francisco. Well, OCLC immediately filed a motion to transfer the case, presumably to a more hospitable location, in their hometown, in southern Ohio. Now, the law permits that to happen for the convenience of parties and witnesses in the interest of justice. And just last week, the District Court for California actually granted the motion. And the judge there said that, among other things, all but 2 of the libraries that have switched from OCLC to Sky River are closer to Ohio than to California. And they are material witnesses. Now, if you remember the 1940s detective stories you grew up on, a material witness, that's the one who saw the murder, doesn't want to get involved, and so they put him in jail. Now, I don't think that they can actually put a college library in jail, but they're going to try to subpoena them, and so those who are more than bystanders will be, no doubt, have the fun thrill of being a part of the case. What's next? Well, the average time between the filing of a complaint and a trial is 29 months. But you see, that number is kind of a phony number, because it consists of cases that get disposed of in 6 or 7 months and cases that last for 4 or 5 years. So that's how they get to the 29. So this is more likely to be a case that's on the farther end of the spectrum, unless the defendant can file a motion to dismiss and win and get the case disposed of at an early time. So if OCLC does make such a motion to dismiss, saying the complaint does not state a cause of action under the antitrust laws, then if they file that, then maybe they can get out early. But it's hard to say what would happen in that case if there was such a motion. The plaintiff, Sky River and Innovative, filed a 39-page complaint, which is quite interesting, available on the internet. It struck me as quite thoughtfully written, with lots of detail, and the Sherman Act is a very tricky law. It's not actually easy to get out of one of these cases if you don't really have a kind of poorly written complaint. So they may be in for the long run. Now, what do I think? I think that you should join me in crooning that great old Henry Mancini song from Breakfast at Tiffany's. Sky River, cheaper by a mile, you'll help me to refile someday. All right, that's it. Now you know.